Hi, I'm Jonathan Rosenfeld. I'm a personal injury attorney in Chicago, and I regularly work on cases where people have suffered injuries related to slip and fall accidents. While these are some of the more common types of personal injury cases, there's a bit of a misconception that if you fall on someone's property, it's an open and shut case. In reality, slip and fall cases can be some of the more difficult cases to win. In order to win a slip and fall case, you need to show that the landowner or property management company either knew or should have known of a dangerous condition which caused your fall. In the first situation, showing actual knowledge of a dangerous or defective condition can be shown by demonstrating that the property owner had received written complaints of the condition. For example, in an apartment building where a tenant falls down a stairway with a broken stair, showing the landlord had received written complaints from the tenants about the stair would be a way of showing actual notice. The other way of showing notice in a slip and fall case is referred to as constructive notice. Constructive notice means the property owner knew or should have known of the dangerous condition due to the fact that the condition was present for an extended period of time. The property owner or their agents should have known about the condition based upon their overall responsibility to inspect and maintain the premises. Again, in the case of a broken stair, showing that the maintenance workers cleaned the area but failed to relay the information to the owner would likely be sufficient to prove constructive knowledge. Another issue that comes up in slip and fall cases is showing that your own negligence didn't result in the fall. Here in Illinois, the doctrine of comparative fault applies to slip and fall cases. What this means is that you can only recover compensation for your injuries if you are less than 50% responsible for an accident. If you are deemed to be more than 50% responsible, it will bar your recovery. Along these lines, if a judge or jury finds you to be less than 50% at fault, the value of your case will be reduced. From the time we are contacted after a slip and fall case, we begin to gather evidence to prove the property owner's negligence. We usually send accident investigators to the scene who photograph the area where the fall occurred and interview people who have knowledge of the condition. If you or a family member was injured in a slip and fall accident, I invite you to contact my office for a free review of your legal rights and options for recovery. We look forward to hearing from you.